All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're on the record in TX210003, the consolidated case of Machu Picchu Holdings LLC versus Pinal County and Rustin Weyes et al. Versus Yavapai County. As you know, we're live streaming, and so we need you to give your name and the name of your client before you begin, please. You'll each have 30 minutes per side, unless you've made an agreement. Otherwise, we'll split appellee's time 15 minutes and 15 minutes, but if you have another agreement, that's fine. We do require you to keep track of your own time with checks on the clock on the podium. Please keep in mind that we have read the briefing, studied the record, and discussed the case in conference before this argument. And with that, you may proceed.
Thank you, Your Honor. My name is Jim Wright. I'm appearing here today on behalf of the taxpayers, and with me at council table is one of my partners, Bart Wilhoit. This case raises several issues, but I believe the primary issue for the court to consider in this case concerns whether the county's assessment practices violate the uniformity clause of Arizona's Constitution, which provides, as I'm sure you know, that all taxes shall be uniform upon the same class of property within the territorial limits of the authority levying the tax.
So are we here to evaluate a constitutional challenge, or does the Constitution inform us as to how to interpret the statutes the legislature passed?
Both, Your Honor. We've alleged that the county's practices do violate the uniformity clause of the Constitution.
And you've also alleged equal protection violations, but our law requires us to avoid constitutional questions where possible. I'm wondering if a constitutional question is even necessary to your position here.
I believe so. Well, we could certainly prevail in terms of the proper construction of 4213-302 on that basis, Your Honor. And one of the legal principles or doctrines that would apply, of course, is that statutes should be construed consistent with the Constitution.
One would hope.
Yes.
Yeah.
In this case, we believe that the constitutional provisions have been violated, consistent with several other cases that we have cited where this court and the Supreme Court have found violations of the uniformity clause.
But put differently, you're not saying that any statute is unconstitutional. You're saying that the application of existing law by the counties, if upheld, would violate not only the statute, but the constitutional provision under which it was enacted.
Yes, okay. I appreciate the distinction.
Okay.
We are not here claiming that any statute is unconstitutional. Okay. I'd like to begin with an example that I think illustrates the lack of uniformity that the county's assessment practices produces, and it may be helpful, hopefully, in the remainder of the discussion this morning. If you would, just assume that Judge Bailey purchased a piece of land and Judge Swan purchased a piece of land in Pinal County, and you each paid $1 million for that piece of land. The assessor, or $100,000, but you paid the same amount. And the assessor agreed that that represented the fair market value of the property. But unfortunately for Judge Bailey, she purchased her piece of property in an area of the county where the assessor has determined that the level of assessment of fair market value will be 100%. And Judge Swan purchased his land in the fortunate area where the assessor decided that it will assess property at only 20% of its fair market value. As a result, Judge Bailey will receive a tax bill that has what's known as a limited property value. That's the value upon which all taxes are based, of 100% of $1 million or $1 million. And Judge Swan will receive a tax bill that has a limited value of $200,000.
So Judge Swan wins in the short term by not paying as much tax, but my guess is Judge Swan's property will not be as well served as Judge Bailey's.
Well, I don't know that that's necessarily the case, but that perhaps could be, Judge Swan.
Okay.
As you can see, the tremendous discrepancy that applies, and those are actual percentages that Pinal County uses to assess vacant land within its county. It's important for the court to understand how taxes are determined and the county's systems in this case, I believe, to rule on the legal issues presented. For every parcel that the assessor assesses, it determines a fair market value or full cash value, same thing, a limited property value, a legal classification, which has a corresponding assessment ratio. Taxes are determined by taking the limited property value, multiplying it by the assessment ratio, and then multiplying that result by tax rate. This case is not about full cash value or fair market value. It's not about the legal classifications the assessor determines. It's not about the assessment ratios, and it's not about tax rates. This case concerns how the counties calculate limited property values, specifically limited property values pursuant to what's known as Rule B in 4313-302. Rule B applies to those situations where a parcel has been reconfigured or where there's been new construction on a parcel or where the use of a particular parcel has changed. And in those instances, the limited property value, according to the statute, shall be established at a level or percentage of full cash value that is comparable to that of other properties of the same or similar use or classification. This level or percentage is known as the Rule B ratio, or the level of assessment that that properties are taxed.
So the county may come back, or the counties may come back and say, yeah, by looking at where properties are, we classified them and we treated them all the same within that classification. What do you say to that?
Well, the answer to that question is, I appreciate the question because it goes to one of the reasons why the county violates the uniformity clause, and that is that location, as our Supreme Court has recognized, as this court has recognized, as many other courts have recognized, is an arbitrary classification.
Is it even a classification?
Well, that's a good question as well. And to that, I think you look to the Apache County case from the Supreme Court. And in that case, the court said class, for uniformity clause purposes, quote, obviously means the grouping of things possessing common attributes.
Okay. Well, go ahead.
To classify, just to cite another case we cited, means to arrange and divide the various subjects of taxation into distinct classes or to arrange in groups. Here,
so I guess my question is, should we view classification as being limited strictly to legislative classifications that are already in the ARS, or does the county have a decent argument that by treating similarly located properties the same way, it has drawn classifications that it can then treat uniformly?
Well, that's precisely the county's argument, is that we can identify locations, we can divide up the county however we would like, we can treat properties on the same street differently than we can treat properties in the same neighborhood, or we can choose the location of the city or the county itself. But there's no question here, Judge Swan, that the county, contrary to what, it's taken two positions in this case, but contrary to what its most recent position is, that it classifies property by location, by neighborhood.
So is there any statutory guidance then to tell us who the classifier is under the law? In other words, if it's the legislature, then it would seem the county loses. If it's the county, it would seem the county might win. And if it's both, the county might win. So how do we figure out who's supposed to be drawing these classifications that are uniformly treated?
Well, there are a few issues raised by your question. First of all, as the county points out, and as this court has said, the legislature determines the classifications of property. And the county agrees with that, and that's where it's gone awry here. It has taken upon itself to determine additional classifications in a manner that violate the uniformity clause.
And what's the authority for the legislature solely has the authority to classify? What's the best legal authority for that?
I don't have the case, Your Honor. I'm sorry off the top of my tongue, but it is cited in our briefs.
Is it People's Fin and Thrift Code? Does that sound right?
That's
it's
certainly
okay
one
if
of
you
the
don't
cases,
know.
but I'm sorry, I can't pinpoint it here as I stand.
Okay, thank you.
It's important to understand how the county does this and why it violates the uniformity clause. What the county does to determine Rule B limited property values is that it creates what it calls Rule B classes. Now, the county now disavows that, but that's what it admitted earlier on in the litigation. The county creates these Rule B classes, and then what it does, and that's okay because they're based on similar use. Those Rule B classes are agricultural, commercial, residential, rented residential, vacant land. And where the county gets into trouble in terms of violating the uniformity clause is the next step that it takes. And it takes all those Rule B classes and it decides to divide the county into various neighborhoods. In Pinal County, it's divided itself into 110 different neighborhoods, and in Yavapai County, it's divided itself into 7 different neighborhoods. These neighborhoods, the county asserted early, were classes. What the county says is after determining these Rule B classes, quote, the assessor has further divided each property type into neighborhoods. All residential property within the neighborhood is one class, and all commercial property within the neighborhood is another class, and so forth. Of this practice, both Yavapai and Pinal County said, division of property types into neighborhood classes by the assessor is a discretionary function to maximize the similarity in limited property value for all property within that neighborhood class. So that is the county system, and that's then, from that, they then create a different level of assessment for each Rule B class in each neighborhood. So Pinal County has 110 different levels of assessment for residential property and for commercial property, more than 450 different levels of assessment or Rule B ratios. Yavapai County also has several. They're not all uniform within the county. These are facts that Pinal County did not dispute that I think put some things in perspective. The county taxes property differently based solely on the location of property. Pinal County has admitted that it does not tax property in the same class uniformly within its territorial limits. Pinal County chose not to try to achieve equal taxation of similarly used property on a county-wide basis, although it could easily do so. And finally, the assessor's establishment of different Rule B ratios for tax year 2018 for parcels within the same class has resulted in unequal tax treatment among parcels in the same class.
The implications of your argument are pretty clear, but I wonder, do you argue too much? Is there any basis, since you've raised uniformity in 14th Amendment, is there any basis for treating a property classified and used one way in Maricopa County different than Cochise County? I can imagine that under some rational basis review, sure, you could make the argument. I'm asking if there's a statute or a constitutional provision in Arizona that actually contemplates those differences.
Well, the uniformity clause itself does, in a sense, Your Honor, frankly, because it requires uniformity within the authority of
each county,
within the authority levying the tax. So, in theory, yes, they can do it differently if they want to, as long as it complies with the constitutional mandates. And in this case, we don't believe it does. We believe that their systems violate the uniformity clause for 3 independent reasons, any one of which would result in a reversal of the tax court's decision. They're independent. The first reason is because their systems are intentional and systematic and result in great inequality in the assessment of property in the same class. That's the McCluskey versus Sparks line of cases, Aileen Char line of cases. Our Supreme Court has said that if a taxpayer establishes that its property is being assessed at a higher percentage of full cash value than other properties, then discrimination will have been shown. The elements to prove a claim under that violation of the uniformity clause are simply twofold. You have to prove that it's intentional and systematic, and you have to prove that the system results in great inequality in taxing the same class of property. Both counties concede the first element, and they certainly don't dispute the latter. The ranges of levels of assessment we've set forth in our briefs. Pinal County vacant land, 20 to 100%. For farmers, it's 59 to 94%. For commercial property, 73% to 100%. Residences, similar. So there's really no dispute about that aspect of violating the uniformity clause, and the county doesn't even address it. The county doesn't respond to that argument at all. The court can treat that argument as conceded by the county, and on that basis reverse the tax court. The county also violates the uniformity clause for a separate reason, namely that taxes aren't uniform within the geographic area that the Constitution says it must be. By definition, since it distinguishes property based on location, they're not all uniform within the county. The county, both counties in this case, admit in their answers that it's the counties themselves that are responsible for levying and collecting taxes within their territorial limits. They don't really respond to that argument other than to say, well, all that territorial limits language means in the uniformity clause is that tax rates have to be the same. There's no authority for that proposition, and the county hasn't otherwise responded. The uniformity clause doesn't say taxes shall be uniform within whatever geographic area the authority levying the tax chooses. But that's precisely what the county's arguments require.
Could the statute say that constitutionally? If the statute delegated to the counties the ability to create taxation zones where their taxation was going to be uniform within these subdivisions of the county, but didn't have to be uniform countywide, would that be a constitutional rule?
That would violate the Constitution. You'd have to change the Constitution.
Well, if that would violate the Constitution, why doesn't it violate the Constitution? And now I'm talking about the equal protection clauses of both the state and federal constitutions. Why doesn't it violate it to have different treatment in different counties? I mean, sometimes in Sedona, for example, it's hard to tell if you're in Yavapai County or not.
Yeah. Same is true in Wickenburg. Part of Wickenburg is in Yavapai County, part of it's in Maricopa County.
Exactly. So why should it be constitutional to say that your fairly arbitrarily drawn county lines can make a difference, but a zone within a county that might actually be tied to the functioning of the county cannot make a difference?
Yeah. I think you raise a good point for equal protection purposes, but the uniformity clause itself limits itself to the territory within the tax, within the authority levying the tax. That's the only answer that comes to my mind immediately, Judge Swan.
Okay.
But surely for an equal protection analysis, I think you raise an excellent point.
Okay.
The third reason that the county violates the uniformity clause in this instance is because it classifies property based on location, and location is an arbitrary classification. Again, Apache County, the court defined what class means for uniformity clause purposes. It's the grouping of things possessing common attributes. And as the Supreme Court has said in America West, citing a long list of cases, and this court has said many times, for a uniformity clause purpose, the class must relate to the property's use, utility, nature, or functionality. And location doesn't relate to any of those things. And that's why location is an arbitrary classification, as our Supreme Court has recognized. As one court put it, classification according to location is not a classification according to any feature inherent in the property itself, but with reference entirely to chance of location, a circumstance disconnected with the characteristics of the property itself. The Supreme Court said, under a uniformity clause, I'll quote it here, quote, under a uniformity clause, property cannot be put in different classes according to location because this would be arbitrary classification. And again, this court said in Barr, location is an illegitimate classification criteria. We've cited many cases that hold that principle. And the county really, candidly, doesn't dispute that principle. What happened below is the county initially said, we classify property based on neighborhood, based on location, and in fact, because we do that, we should prevail. We then pointed out the case law that says no, location is an arbitrary classification. And then what happened? The county did a 180-degree turn and said, oh, well, we don't classify property. I think that is simply belied by the record. And again, we could review those instances where the county represents that each neighborhood constitutes a different class. Residential property in a neighborhood is one class. Commercial property in another neighborhood is another class. And the county walks a fine line, candidly, in their briefs on this point, because they have to somehow account for their systems, but they can't use the word classify to say what we classify by neighborhood, given the position that they've taken. Their view is that because all of our case law on this issue concerns classification, if they don't classify, we can't prevail. The converse is true in this instance. If, in fact, they do classify property, the county does not prevail. The county, again, has to walk a fine line, and so how do they describe this in their briefs? Yavapai County says, to calculate limited property value, the assessor places parcels in one of 4 distinct categories. Those are their Rule B classes: commercial, vacant, agricultural, and residential, close quote, end quote. The assessor then places parcels into one of several market areas. And Pinal maintains that its system requires Pinal to place parcels into categories for purposes of calculating limited
Well, the
property value.
categories you don't have a problem with, right? Residential, commercial, industrial.
Correct.
Those are legitimate.
As long as it's the same throughout the county, that's fine.
Yeah.
We're good with that. We don't have a problem with the county's legal classifications, and we really don't have a problem with their Rule B classifications, because 4213-302 says you can look at either property of similar use or in the same class. So we're fine with that. It's when the county, and if they stopped there, there would not be the disparity, and Judge Bailey wouldn't have $1 million limited value, and you wouldn't have a $200,000 value. You would have the same limited property value.
Mr. Wright, let me ask you a two-part question.
Sure.
First, what's the practical effect if this court were to accept your interpretation of 4213-302 and the uniformity clause? What's the practical implication?
Sure.
And I know Pinal County, you're challenging 2018, and Yavapai County, year 2019. But what's the practical effect of that for property taxpayers in each county, looking back, looking forward from those years? And two, should this court consider the practical effect in interpreting that statute or constitutional provision?
The relief requesting, the practical effect, is that this court should hold unconstitutional the county's practices and order the county to do what several other counties like Maricopa, Pima, Apache, Graham, Yuma do, which is to have the same Rule B ratio for property in the same
How far back?
class.
How many years back do I get to challenge my tax bill if you prevail here?
Well, your question really implicates some others, which is could if the court rules, 3 years is the notice of claim limitation, Your Honor. So at this juncture, we're in 2022. If the court ruled tomorrow, a taxpayer could possibly go back to 2021, 2020, and 2019, maybe. And that's assuming that it would constitute an error. But the practical effect is that the county would be ordered to set a county-wide Rule B ratio. That's the practical effect. And we haven't asked for relief going back beyond 2018. This is an illegally collected tax claim brought pursuant to 421105. So the practical effect would be a county-wide Rule B ratio for all property. It wouldn't affect any taxpayers, candidly, who aren't part of this case. So the practical effect wouldn't be to go back and recalculate the limited property value of taxpayers who aren't parties to this litigation.
Why wouldn't it affect any other taxpayers?
Well,
Shouldn't it, I mean, you're arguing uniformity.
Sure.
Shouldn't it affect all taxpayers?
because they're not parties, Your Honor.
No, but presumably
They
the
have-
result of this case will be an opinion by this court and perhaps
Sure.
another. Won't other taxpayers want to take advantage of whatever the
They
rule
might,
turns out to be?
well, they might, but then going forward, if the county persists in this practice, going forward, then they could bring such a claim. The other practical effect, Your Honor, that it has is that setting a Rule B limited property value is crucial, and one of the reasons it's crucial is because it sets the base for limited property values in future years, and we addressed that in our opening brief. So if you set the value at where it's supposed to be, then that value will increase in future years by 5%. Was there, I'm sorry,
The
was there another
second
part of the
part
question?
was, should the practical effect play into how this court interprets a statute or not?
Well, I think,
In this instance, not generally.
I'm not quite sure what Your Honor is thinking when you say practical effect. I don't see it as having, earth-shattering consequences. This isn't a case where, for example, in the Van Gilder case the Supreme Court just mentioned, I think it addressed the prospective-only relief. That's not the case here. The county hasn't asked for anything like that.
Well, but do we need to be considering that? Because if you prevail here, some people's taxes are going to go up and some people's taxes are going to go down.
Nobody's taxes will go up. I don't know how you draw that conclusion, Your Honor, because, well, go ahead.
I don't know what sort of LPV the county's going to adopt if you prevail here.
Probably not the 20%.
No, it should set the county-wide case, and maybe I'm inferring something from your question.
Well, if I'm paying 20% now and you prevail, my guess is my taxes are going up.
No.
Really? You think the county's going to just leave it at 20%?
Well,
Everybody's going to get a tax cut? I'm not so sure that's required by your position.
no, I don't. I think what will happen is the county will change the taxes for those people who are parties to this case.
Yes, but then other people who would rather not be paying such high property taxes are going to bring actions. And the county is going to have to anticipate those actions in the way it sets future LPVs. This is not, you cannot contain this to your clients. This is a precedential case.
Yes, but remember, Your Honor, the county's not going to go back and say, Judge Swan, we messed up. You should have been at 80%, not 20%, so pay us more taxes.
No, but in the future,
Yes, in the
my
future-
taxes may go way up.
No. Your property is set at that 20% limited value, and they can go up 5% a year.
Even though that was done unconstitutionally.
Yeah. That's right. I don't know how the
Sorry, I
county...
must be missing something, but it seems to me very unlikely that if we make a constitutional or quasi-constitutional determination about how tax rates could be set and do it in a published opinion, that nobody is going to try and use that opinion to alter their tax rates.
Well, Your Honor, keep in mind, we're dealing only with Rule B limited property values.
Okay.
Okay, first of all, concerns a relatively small percentage here, less than 5% of the taxes. And what would the argument be going forward? Oh, the county treated me constitutionally, so I don't, so I've got some kind of a claim? I guess
Well,
I
the
don't see
argument
it.
would be this. I've been paying 100% LPV, and now the courts say that things have to be uniform across the county. The county, in response to that, just made the LPV, let's say, 55%. Well, all that time I was paying 100%, I shouldn't have been. I want my money back.
Then Judge
That's what
Bailey ought to
taxpayers
file
will
a
say.
notice of claim, and she ought to say, yes, you unconstitutionally taxed me, and I should get some relief.
That's going to be a massive administrative undertaking.
You're assuming the county will undertake that. Frankly, I doubt it will. But,
I don't understand what you mean. How could they not undertake that if somebody's filing a notice of claim?
well, if they're filing a notice of claim, yes, absolutely.
So they're just going to use the squeaky hinge gets the grease
Well,
kind of theory?
I don't want to speculate on what the county will or wouldn't do. But I think the court needs to apply the law. And going back to your question, I don't think it'll have a tremendous avalanche of problems that perhaps I'm inferring. And perhaps the best evidence of that, Your Honor, is that's certainly not an issue that the county has ever raised.
Well, and it may not be an issue that's before us, and I would tend to agree, even if compliance with the law creates massive problems, we're here to enforce the law,
Yes.
not avoid problems.
Yeah, and
So-
I'm not sure the Constitution has, someone once said, a price tag on it. I'd like to remain the little time I have left for rebuttal.
Thank you.
Good morning. My name is Jim Sousa. I'm with the Deacon C. McDonald Law Firm in Tucson, and I'm representing both counties today. With me at council table is Scott Johnson from the Pinal County Attorney's Office to keep an eye on me and make sure I'm not wasting the county's money. Judge Swan, let's start with you. The first question you asked had to do with the statute. So let's talk about the statute. The statute was adopted after a voter resolution was passed in 1980, and the whole idea was simple. California had passed Prop 13, skyrocketing property values. People got very stressed out over whether their property taxes were going to be rising just as quickly as their house values. And this is houses. Houses are owned by people who vote. So Arizona sends a ballot proposition from the legislature to the voters, and they approve this new concept. And it has two components. The first component is it sets a cap of 1% of the house value, and it's only for houses, can be the taxes, and that was in Section 18 of Article 9. The second component is this adoption of a theory, which nobody had before, of a limited property value, sort of an anchor, if you will, that keeps the ship from drifting. So when the house value goes up 30% a year, the limited property value goes up maybe 10% a year. Some of the tax rates applied to the limited value, some of the tax rates applied to the full cash value. That's the system that we had. So right out of the gate, what do? Well, we asked the Department of Revenue to figure this out. It's a whole new concept. What are we going to do? The department in 1980 has to figure out what do we do with new properties. We know what to do with existing properties. You just add 10% to last year's limited property value. But for new properties, we have to figure out how to do that. So the words of the statute pretty much are the same today as they were then. And for all the counties in Arizona except Pima and Maricopa, the Department of Revenue, using its computers, determines that a market or neighborhood system is the best way to implement this new requirement that when we have a change in property characteristics, we have to figure out what the limited property value is going to be. We can't just say it's 10% more than last year.
Right. You may be telling me something I don't know, but you're saying the Department of Revenue is doing this? So the Department of Revenue has concluded that Pinal County has more than 7 times or 10 times the number of neighborhoods as Yavapai County? That seems like a big leap for a Department of Revenue.
No, what I'm giving you is the historical and how we got from where we were to where we are today.
Oh, okay.
Okay,
But
let's back up.
I just want to make sure I understand. Are you saying the Department of Revenue is the department that suggested this neighborhood system to the other counties?
Not just suggested it, they implemented it for every single county except Pima and Maricopa, which had their own computers to do their own work. So the smaller counties, Pinal and Yavapai, asked the department to do the calculation. This is in the record.
So where in the record?
It's in the court's rulings that talks about the department implementing this in 1980 and doing it for all the counties. Yavapai and Pinal both detached from the department in 2010.
Right.
So for 30 years, 80 to 10, the Department of Revenue, for billions and billions of dollars worth of property taxes, used the market neighborhood system. They created markets and neighborhoods.
Are they directing the counties to follow that system?
We're going to get there.
Okay.
So they used that for 30 years. So if the appellants are right, then for 30 years, the Department of Revenue did it wrong. Judge Viola asked that question. If I understand you correctly, the Department of Revenue made a mistake for 30 years for almost every parcel in the state of Arizona. And the answer was yes, it was all illegal. So that was where we were in 2010. So then the counties detached.
Every Rule B parcel.
Yes, sir. So then we detach in 2010, right? And now the counties are obligated to apply Rule A, that's easy, and apply Rule B. So what do? Pinal County just simply takes the department system, and they continue to use neighborhoods and markets. And Yavapai County makes a more sophisticated decision. And this is important, and I want you to think about this. Yavapai County says the market value and limited property values are pretty much the same. This is a stagnant market in 2010. Everybody's almost at 100%. There's really no benefit in doing a segment, creating markets, to do a limited property value calculation for Rule B properties, because we're almost all at 100%. So Yavapai County makes the decision to use a countywide ratio. And they're allowed to do that because the statute gives them the flexibility to do that.
Where?
Because it says the same or similar property, and it says comparable. So they're creating house, rental, and residential all together, and they're saying, if we decide to use a countywide system to create a limited property value Rule B ratio, what's the practical effect of that? And the answer is, all over the county, we're going to get about the same ratio anyway to the full cash value.
Right, but Yavapai County, I mean, does it say that a single-family residential parcel in Prescott is going to be treated differently than one in Chino Valley?
It is not. It says that they're all single-family residential parcels. If they're primary residents, they're all in Class 3, but they've taken both the residential in Class 3, Class 4, and Class 6, and they've added the rental ones as well, and they threw it into one ratio, and they did that for several years after the handoff from the Department of Revenue. But then when market value started to change, Sedona went up, Prescott went up, the separation became even greater, and they said, now there's a reason to do this. And this keys off of the interesting example that was used and that you guys followed, but I think you followed it to the wrong place. So let me have you follow to the right place. If you both bought $1 million piece of property and you decided to construct a house on it, the county would have an obligation to come out and look at the property when it was done, and they have to do something, right? We know what the parcel number is. So Judge Swan, they come out to your property and say, 4,000 square foot home, this is what we estimate the fair market value of it is, added to the piece of dirt, $1.5 million. Judge Williams, same size house.
Judge Bailey, but that's fine.
That's fair enough. Judge Bailey, congratulations. You have $1.5 million house as well. All right, so now this is the full cash value. But now we have to make a limited property value calculation. And how are we going to do that? What you were erroneously told is the county just picks 20% for you and maybe 100% for you. The county doesn't pick something. The mathematics of the area that you live in dictate what that ratio to the full cash value is going to be. So for you, mathematics, math, all we're doing is taking the limited property values, dividing by the full cash values, and it tells us it's 80%, it's 60%, it's 90%. This illusion that the county picked 90% for you and 20% for you is a fallacy. They didn't pick anything. They simply said, where you live, Sedona, let's use Yavapai County example, where you live in Sedona, the prices are taking off. So actually, the limited property value for residential properties is 60% because the full cash values are skyrocketing. So limited values are creeping along, but the full cash values are taking off. So your $1.5 million, right? 60% of that, I don't know, 900,000? Close enough. But Judge Bailey, where you picked out a house to live in, you're in a rather remote area. Let's call it Seligman. There's not a lot going on in Seligman. Your house is probably the largest one there. But the limited property value and the full cash value ratio for all the houses in the rural Yavapai County is like 95%. So your $1.5 million home has a limited property value of 95% of that, so let's say $1.35 million. So now we're done with establishing the full cash value and the limited property value. What comes next? The answer is, where your house is located in Seligman, you have school district taxes, you have county taxes, jails, city, all the other taxes that are within the jurisdiction where your house is located. You're paying for all those things that you support. Judge Swan, same answer, right? Far different tax rates, likely far different tax rates, because you live in different areas. And that's okay. That's the way the system works.
So I pay less and I get less?
You're paying whatever the tax rates are in Sedona for the property's assessed value that you own. And all of your neighbors are paying exactly the same tax rate on their assessed value because where your parcel is located, it touches the same political jurisdictions that they're all in. Judge Bailey, your house is in Seligman. You don't have the same school district. You certainly don't have the same city taxes. You have different taxes. And so as a result, the system that the legislature set up was counties, go figure out a limited property value ratio. Find the best way to do that. And as the tax court held, and I wrote this down, that the system of using markets yields a more uniform and consistent limited property value between all the properties that are in the same area that bear the same tax rate.
So from a public policy argument, you may be 100% right. But how do you jive that with the plain language of the uniformity clause?
It's pretty straightforward. The uniformity clause has been interpreted by this court and the Supreme Court to require certain things. And it talks about when property classifications are being made by the legislature, and everybody agrees, the legislature decides that houses are residences. A house which is owner-occupied, the primary residence is in Class 3. There's a whole bunch of other things in Class 3. But a house which is owner-occupied as a secondary residence is in Class 4. Well, why couldn't they be in the same class? That would seem to make sense, but they're not. Legislature made two different classes. They task the assessor with going out and saying, what do we have? And the answer is, we have an owner-occupied secondary residence. It goes in Class 4. Once the assessor identifies that on its records, then all the things that happen to all the other properties in Class 4 happen to that residence. That's what classification is. The assessor's job isn't to determine. I think a much better job would be to put in Class 3 with the owner-occupied primary residence. They don't get that discretion. Their only discretion is, what is it? I looked at it, I saw it, this is what it is, and it goes into legislative class number 4. That's all the assessor gets to do. Then it has to determine the value. It has to do the full cash value and the limited value. As Mr. Wright said, not very often, maybe 5% of the time, this Rule B thing happens. And you have to go out and do something different than just adding on a percentage from the prior year of last year's limited property value. The assessor doesn't go and say, I'm eyeballing it, looks like 74%. They're running the numbers in that area.
How often do they run those numbers?
Every single year.
Okay, so you're saying these Rule B ratios just set themselves based on market forces?
I'm saying exactly that. Because Rule A increases the limited property value for everybody else, the other 95%, right? 5% of Rule B, 95% of Rule A. It increases them every single year by a certain amount. But the full cash value is going to be skyrocketing, which is my Sedona example, or it can be stagnant, which is my Sligman example. And if they're stagnant, the Rule A increases are going to get you pretty close to, if not exactly equal to, the full cash value, which now means you have 100%.
So why is Yavapai County so much more homogeneous than Pinal County? Why does one have 7 neighborhoods and one has 110?
It's a decision made by the county assessor as to what best determines
And under
a
what,
fair and equitable.
Under what authorities does the county assessor make that determination? I think that's the crux of this case.
13302, which tasks
Read me the language that gets him there.
that the county assessor shall set the limited property value at a level or percentage of full cash value comparable to other properties in the same or similar use or classification.
It doesn't say anything about the same or similar area.
Use or
Yeah,
classification.
use. A single-family home is a single-family home, whether it's in a good area or a less desirable area. So
I agree.
where does it give the assessor the ability to zone out a county to create these different neighborhoods?
Because
And where does it say assessor in the statute?
Well, it's the duties that the assessor has to calculate a limited property value, Your Honor. So after the legislature creates those classifications, they task the assessor with implementing the property tax system.
But it doesn't task the assessor with coming up with the Rule B ratio.
It does task the assessor with coming up with the Rule B ratio. It has to calculate both a full cash value and a limited property value for every parcel every year.
Well, once you know the ratio, I guess the calculation is pretty ministerial.
Just math.
But if the assessor is coming up with the ratio and can do it, presumably under your argument, Pinal County might suddenly have 220 neighborhoods next year.
They could, in fact, have 220 neighbors. The reason
Under
that
what possible authority?
under the authority that the Department of Revenue had the same number of neighborhoods when they handed it off in 2010,
That's
and
not
Pinal
authority.
chose to continue to use those neighborhoods.
The Department of, I think thankfully, we don't have a state version of Chevron here. I don't think the Department of Revenue has any authority at all to determine whose neighborhood is which.
The Department of Revenue, though, had the obligation in 1980 to come up with a system that actually complied with the voter requirements.
Right,
And that's the
but
system.
you're taking responsibility for it from 2010 on. So now it's you making that decision.
Those things are true.
Okay, and you're saying that the reason you can do that is somehow in the statute that you're justifying under a same or similar use or classification, when what in those words tells you that a classification other than grouping them differently maybe than the 9 that are set out, and you've grouped them into 6, residential, vacant, agricultural, but what about that also, and that's I think all of our question, gives you the next step authority to then break that down even further?
Comparable other properties. The houses in Sedona are comparable to other houses in Sedona. They have the same market dynamics
That have the
driving.
same, but it's comparable to other properties of the same or similar use or classification.
In the same or similar use or class? Does not say in? Could say
Full
of.
class
Other
value that is
properties
comparable.
of the same.
All right, fair enough.
Of, yeah.
All right, so it's comparable. So the houses in Sedona have their full cash value escalating because of the
Listen, if
market.
you're making the premise that it's comparable to the other neighborhoods, we get that. But the statute says comparable to that of other properties of the same or similar use or classification. And so you have said we're further classifying or dividing or neighborhooding or however you want to
Right.
say that subset, that you're doing it further than just classifying whether it's vacant or whether it's owner occupied or whether it's agricultural. That's a use. When, you know, we have I can't say the name of the case that begins with Q that
Kissimar?
that says, yes, you're changing use when you go from category, you go from
3 to
3 to 4. Okay, you're owner occupied and then your owner secondary property. That's a change in use. Okay, and then you have classification, which we've already established is agricultural, vacant, residential. So where in this statute do the counties have the authority to further break up those classifications in a way to say, oh, no, they're comparable as we've broken them down further? Where's the justification in the law for breaking them down further and treating someone in Seligman different from someone in Sedona, regardless of how equitable it seems in the examples that you're giving us? Where's the authority?
Okay. I believe that there's a combination of two things. One is the legislature's decision to give the assessors the ability to determine full cash value, determine what the properties are being used for, put them into different classes, calculate limited property value under both Rule A and Rule B. So they've delegated that authority to them. As guidance for that, the assessors looked after how the department did it for 30 years.
Okay. Other than that,
As guidance for that. And by doing it that way, you result in a uniform and equitable treatment of people who are subject to the same tax rates because they live in the same areas. Again, your Seligman versus Sedona
That's
argument.
a great argument to make to a legislative committee, but the legislature hasn't passed the statute you just outlined. So what do we as a court do to say that the county assessors have this discretion to suddenly create 220 neighborhoods on, a whim?
Not by a whim. They have to have some basis for doing
Well,
so.
even if there's a good basis, a good public policy, equitable argument, that's the question.
Yeah, and I think the answer is you go back to why do we have this at all? And the answer is it's a circuit breaker. It's a circuit breaker to keep taxes down.
It's a shock absorber to prevent.
Okay, better term.
Yeah, well, you're trying to prevent too much change in any one year, but the problem with the system you have, as I see it, is that you get a new assessor, and the assessor decides, well, I want to go from 110 neighborhoods down to 12, and then the next one decides they want 1,000. That seems okay in your view, and that does not seem to have anything to do with either the statute or the principle of uniformity.
I would have difficulty believing an assessor would want to do that because of the logistics of having to then calculate for very minuscule differences in
But they
full cash
could.
value.
Even if they
could.
changed it by one neighborhood.
Okay,
that's
which they did.
still-
Yavapai County did that. They looked at it and decided that the Camp Verde and Cottonwood areas in 1 year should be combined in the next year, right? So they did that. The idea is that the assessor is vested with this kind of, you have to go figure this out. We just write the statutes, go figure it out, and do something which is fair, uniform, equal, consistent, so on and so forth. That's what they've done.
Right, okay, so now if I'm in a neighborhood that's paying 20%, and Judge Bailey's in a neighborhood that's paying 90%, and you're saying the market just sort of set that up for us, what if the next assessor decides to change the boundary of my neighborhood just 100 feet, and suddenly I'm in Judge Bailey's neighborhood paying 90%?
Yeah. Again, you have misconstrued the paying 90%, paying 20%.
I'm using that as shorthand. I understand what the Rule B ratios are for, but no, it's not paying, and property taxes are in REM, and so excuse the shorthand, but my tax burden, my property's tax burden, will change depending on whether I'm in one neighborhood or another.
Absolutely.
And it sounds like you're telling me that the assessor could wake up one morning and decide that things are looking good in this area, so we're going to expand this neighborhood to include more property.
That's true.
And I don't see a statutory command that allows the assessor to do that.
I believe that 1332 is comparable other properties. You're looking at comparable other properties. The Sedona cases are different than the Sligman cases.
But why do you say that without saying the end of that sentence? I mean,
Well, I'm using residential properties. The same or similar use, which is residential.
right? But
comparable
you just told us
residential
that
properties.
Two residential properties are not being treated the same.
Because they're in different areas which have different factors affecting their
But
fair
the
market
statute says
value.
use or classification. There's nothing different about the use, right? A single-family home
Right.
is a single-family home.
I agree.
And the classification is that which has been set by the legislature, which covers things like agricultural versus residential. But nowhere do I see anything just talking about comps the way an appraiser might using location. I
Okay.
know that we're drilled in location, 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 but it's not in the law.
That's true. We don't have location in the law, but we ask the assessors to go out and determine a full cash value, and then in these limited circumstances, create a ratio.
Exactly. So when the assessor goes out and determines a full cash value, presumably it's perfectly fine for them to use the location of the property as a proxy for the value of the property. That appraisal stuff that assessors do, much like private appraisers, can rely on location. I don't think that's challenged here. But creating a formal distinction between areas after the full cash value has been determined seems to be where your argument falls apart.
But the consistency is, Your Honor, that we've created the full cash value in Sedona by looking at all the comparable residential sales there. Now we're going to have to apply in very limited circumstances a ratio to that full cash value for the brand new property that was just constructed. Where are we going to get that number? Are we going to use the entire county? Are we going to use, well, we're applying it to the full cash value that was just created with this market. We're going to use this market for doing that, and that's what this system does. It created the full cash value and then created a percentage of that full cash value to use in this limited property value calculation, which creates consistency so that you and all the people on the street next to you pay exactly the same tax per dollar in full cash value. If we use this other example, and we use the countywide rate, your house may suddenly have 3 or 4 times the limited property value that all of your neighbors have per dollar in full cash value, because we use a countywide rate. And because
So I don't get to take advantage of the shock absorber from a time when my property didn't exist.
That's right.
Should I be worried about that?
You should be worried, because why are you getting to pay higher taxes than all of your neighbors when the same fair market value dynamics are dictating the value of your house? And we base everything in tax on value. Everything in tax is based on value. And so as a result, your value was determined by that neighborhood. The limited property value ratio was determined by that neighborhood.
Yeah, but if everything is based on value, and we all agree that you can use location to determine the fair market value of a property or the full cash value of a property, why does location get even more input into the equation than that?
Because it's now determining for this very special circumstance, which we can't just add 10% to last year's number, 5% to last year's number. What do we do with limited property value in your situation? And because we've said we're going to put a percentage or level on it, it's a level of the full cash value that was just calculated.
So if I build a property and I'm suddenly hit with a larger tax bill than my neighbor, my position is I should be treated as though I had invested earlier.
No.
And by that rationale, there are stocks I'd like to buy for last year's prices.
I'm with you. But you don't get to pay more taxes. You get to pay the same taxes under our system for every dollar of full cash value. This is the best example we have. Pinal County, top of the world, vacant land. It's in our briefing. Because of what happened there, the limited property value was at 20% of the full cash value. Complete aberration. So in that one circumstance, if a vacant landowner decided to create a new parcel, the county would come out and say, based on comparable sales, what's your full cash value? Under the appellant's theory, the limited property value would be to 82% of that full cash value. All the other neighbors are still sitting at 20 because they had a Rule A event and this person had a Rule B event. So they're not placed on par with the Rule A people. They're not even close to being on par. They're paying 4 times the amount of taxes that the Rule A people were. and yet it's the same property, in the same location, used for the same purpose, same taxing jurisdictions, and just by fortuity of using a countywide ratio, they're paying 4 times the amount of taxes. That's the constitutional violation of using the countywide system.
You make very persuasive arguments
It's my
on
job.
policy,
Yeah.
and except your job might be better applied a couple blocks down at the legislature.
I don't like
we're
those people,
sitting- what?
but yeah, I don't like those
We're
people.
sitting here dealing with a statute that has a very few words, and all of the important rational policy arguments you're making need to fit within those words if we can uphold them, because we are not a policy-making body.
I understand that. Then what about 30 years of uninterrupted practice for billions of parcels and billions
I can
of
think of a
dollars
lot
in
of
refunded
practices
taxes?
that went on in this state, in this country for 30 years that aren't
The difference
acceptable.
being that the Department of Revenue is supposed to be implementing this system. The legislature tells them to implement this system and direct the county assessors, and this is the way they chose to
And
do
the
it.
Department of Revenue gets sued all the time for making mistakes under the law, and sometimes it loses.
And sometimes I'm the people suing them, and that's okay too.
Mm-hmm.
But the point is, that's the practice that they had. When Judge Viola looked at this, she said, look, it doesn't say exactly how you're supposed to do this. That's true. Nobody here can say exactly how you're supposed to do this. The best you can do is to create groups, all residential property are residential and rental residential, all the other ones too, and then come up with a system so that when you figure out the full cash value and you have one of these outliers, right, 1 out of every 20, that makes 5%, that is a rule-based situation, you're going to apply something to that. The Department of Revenue said, this works. Now, for 30 years, legislature could have jumped in, courts could have jumped in, anybody could have jumped in and said, you know, a better way of doing it would have been this. Nobody did.
I don't
And
even know
so
if-
Judge Viola said, that's good enough.
Yeah, I don't even know if your opponents are saying that their way is better. I think they're just saying that it's the law. And courts don't sua sponte jump into these things. The legislature may very well want to revisit the language in its statutes, and it has the freedom to do that, but we don't have the freedom to rewrite statutes.
But for 40 years before 2020, when these lawsuits were filed, nobody is in front of the courts saying that these systems are invalid. I'm not saying a long practice means a good practice, but a long practice, if it was wrong, you would think somebody would have called it out and said, it doesn't seem to meet the statute.
Well, why is the practice uniform in Maricopa and Pinal?
It's not uniform in Maricopa here. They just use a countywide ratio,
Well,
and they
that's
get
what
the
I mean.
aberrations. They get the aberrations that I just talked about.
Okay, so if in Maricopa County, which is, a fairly sizable county, a countywide ratio can work without the world falling apart, why does Pinal County need a different system?
I would ask the obverse, why is it in Yavapai County, which has got lots and lots of parcels of different types in different areas with different market areas, this system has worked for 40 years, why is this system a problem?
Well, I appreciate
The world's not
answering
falling
the
apart there
question with the
either.
question, but now let's try answering it with an answer.
It's not falling apart in Maricopa County because this Ruby stuff is pretty nuanced, it's pretty sophisticated. Nobody really has dove into this until we started to see a rash of lawsuits that started to be filed involving limited property value because all the tax burden is shifted over now to limited
The
property
vast
value.
majority of taxable value in this state has been done with a countywide ratio for 40 years. So I turn it back to you. If it's been good enough for 40 years with the vast majority of taxable property, why isn't it good enough for Pinal County?
I would say the vast majority of the parcels located in the state have been done with the neighborhood markets for 40 years. Why isn't that good enough either? Thank you, Judge Swan.
Okay.
I don't have anything else, although I did want to point out one last thing because I worked really hard on this. This territorial limits argument I thought was really interesting. I had searched high and low to find anything that would describe territorial limits. And thus, I was excited in one of the reply briefs when we saw uniformity within territorial limits for the taxing authority is an indispensable requisite, the uniformity clause, citing the Smith versus Mahoney case from 1921. And so I thought, oh my God, this is it. And so I went to our library. I noticed the other counsel's laptop failed. I wasn't going to take a chance. And I got the book out, and this is really a fascinating case, but the actual wording is, this palpable discrimination robs the law of the indispensable requisite that taxes shall be uniform upon the same class of property within the jurisdiction of the body imposing them. And so, to me, it's not anything about territorial limits. This was a state tax where the state had taxed sheep coming in from across the border, and they had put a zero rate on sheep that were actually already here. So the court, probably pretty far ahead of its time, said that just robs it of uniformity because out-of-state people pay something and you pay nothing at all. So there wasn't territorial. But the one thing I thought was finally good, on the inside of this is a stamp, and it says Ivo DiConcini. So Justice DiConcini apparently was he started the firm, very concerned about making sure people knew what was his. We'd ask you to affirm the tax court because we think that the judge is smart and figured it out, and she ruled in our favor, and the uniformity and equalization arguments, I think, would fall by the wayside. Thank you.
I'll add, even if we disagree, it doesn't mean we think Judge Viola isn't smart.
I think she's really
Thank you.
smart. It's pretty impressive.
Well, and that is the most interesting prayer for relief I think I've heard in my whole career by an appellee. So,
I'm doing what I can. Thank you.
Yeah.
Counsel.
Okay, Jim.
I only have a few seconds, so I'll be brief and try to address the issues raised. First of all, it's telling that the department isn't participating in this case. The record shows that they don't take a position as to whether or not the county's practice violates the uniformity clause. The central issue, as I listened to the argument that the court needs to decide, I think, or one of them, if you will, is what is the geographic area within which taxes must be uniform? Here, we believe that that area is the county. Lots of comments about, for 40 years, we've been doing it this way or that way. I would just remind the court of the court's comment in Bade, quoting Southern Pacific, we cannot countenance the willful, systematic, and intentional violation of the law, no matter how long continued. In addition, I think you made a good point, Judge. A residence is a residence is a residence, and in the record, the counties agree that they apply the same criteria to determine what legal class and what Rule B class properties fall in. So properties, a residence in Sedona should be treated the same as a residence in Wickenburg.
But you would agree, would you not, that when the assessor comes up with the full cash value, the assessor can consider location?
Of course.
Okay.
And you made an excellent point. It's appropriate in that instance, and location's already
It's a
taken
market
into account.
factor at that point.
Absolutely.
All right. Thank you, counsel.
Thank you.
Thank you both for your arguments. We'll take the matter under advisement and issue our decision in due course. And at this time, the court is adjourned.